This is a time set for oral argument in our case number CV18-0687, Goldman versus Sahl. Each side is, and we'll talk about how we're going to hear from the sides in just a second. Each side is given 20 minutes for oral argument. If appellant wishes to reserve a portion of that time for rebuttal, you may do so, but you need to keep track of your own time at the podium clock. For those in attendance, I would make sure, or ask you to make sure that your phones are off to avoid any interruption of counsel's presentation and embarrassment as well. We have reviewed the filings, we've reviewed the record, we've conferenced the case. We'd encourage you to keep that in mind as you present oral argument. Also, please, when you approach the podium, announce your name and the party you represent. The proceedings are being recorded and will be posted for further consumption later. We do have and we appreciate the various amici briefs that have been filed with the court. We appreciate that additional guidance and insight. We have granted a request by the Attorney General's office to provide 5 minutes worth of oral argument. The way we're going to structure that is, instead of the usual sort of 3-step, we're going to have a 5-step. Appellant will go first, reserving the amount of time that you wish to. We'll hear from appellee, and you may reserve, or appellees, and I'll defer to you as to how you wish to allocate time, if that's what your thought is. We will then, but reserve any portion of time that you wish to address the amicus argument. We'll then hear for the 5 minutes from amicus, then look back to appellee if they have anything they wish to offer, and then hear last from the appellant. So any questions about that process? That's how we're going to, I'm glad that that was fairly clear. But with that, let us first hear from counsel for appellant, and I'll look to see who is going to present on that as well.
Thank you, Your Honors. Dennis Wolenchek and Bartness on behalf of Goldman, and with me is Paul Vaporian and Mr. Goldman. I'm going to try to reserve as much time as I can, but I want to hit some points before I do, if that's okay. First, I tell the court my belief is that while there are limitations, as we know, that are placed on First Amendment rights, you can't shout fire in a crowded theater. There are limitations placed on the privilege to defame someone in the course of a judicial proceeding. And I think that the best thing this court could do is to just read Green Acres. I think Green Acres was misapplied, misunderstood, whatever, by the lower court, with all due respect to that court. I think the court cherry-picked certain points out of Green Acres without, in all candor, looking at the rest of what Green Acres actually said, because Green Acres actually says, I believe, the reverse of what the court said. While everything that the court quoted from is in there, what the court missed was the rest of the story, because then the Supreme Court in Green Acres made clear as to what I was just saying. There's not just a blanket privilege because you file some proceeding. In this case, there was no proceeding filed that was argued below at all. There wasn't even litigation in the air on January 27th about any such litigation. There was no reason to send any letter about Mr. Goldman's ethics to people that they didn't, that is, the defendant appellees didn't even represent, including to Mr. Goldman's own clients.
Mr. Wilczek, I'd like to walk you through that just a little bit, if I could, just so I can understand your argument. You're not disputing that, in fact, there can be a litigation privilege for pre-filing of a case.
I believe Green Acres makes clear that in certain limited circumstances, and that's the key to this, not just a blanket, whatever you want to do before a litigation, and then you file a lawsuit and you say, you know, I'm exempt from any good faith requirement at all. I can say you're a child molester and then just file a lawsuit saying it, and therefore I'm protected. No, that's not what Green Acres is saying at all. There is a limited exemption as a
litigation privilege.
Limited in nature, as pointed out by the court, and examples the court provides. For example, a demand letter to another side. In limited circumstances, which the court describes there, I don't have them all committed to memory, but an investor, I think, asking questions that are legitimate about a potential lawsuit that's threatened, things of that nature.
Well, but it doesn't require that there actually be something filed.
Well, I disagree with that with all candor, because I don't find any case, and if you do, that's fine, I'm happy to discuss it, but I don't recall any case in which no lawsuit at all was ever brought and that privilege was exercised. That's just my recollection to my reading of the cases. So, no, I don't, with all honesty, agree with your position. There was no litigation contemplated at that time with these people. These lawyers don't represent owners in the association, particularly his clients. They had no business whatsoever. That is the recipient, which if you read Green Acres talks about. The importance in that case, there was a reporter, which I think would even be more of a nexus, a reporter who was claiming he had an interest in the case. And the court said, no, that's not a substantial relation to the case, and it's not a sufficient nexus or good faith. In this case, these people, the recipients of this defamatory letter talking about Mr. Goldman's ethics, according to them, which were ultimately rejected summarily by the bar, not even a hearing, this defamatory letter had no basis, no purpose to be sent whatsoever to those people who had no interest. A reporter might be claimed to have some interest. There might be claimed to be some public policy reason to talk to a reporter. There is no public policy reason, if you look at the conditional side of the privileges, that there's any reason at all to have told these people anything about Mr. Goldman's ethics, except a bad reason. And on the absolute privilege, which is what the court found, not even a conditional privilege, so I won't spend a lot of time on conditional privilege, on the absolute privilege side of it, it's even worse. There clearly is no absolute privilege to, in bad faith, talk about another lawyer's ethics to people that have no interest in it whatsoever, aren't going to be witnesses in it, don't care about it. What is the point of that? How does that relate? And that's why I say I disagree with you. You have to relate somehow to the litigation that's being contemplated. The only litigation below that the record reflects that they could come up with at the time on January 27th was a supposed moratorium against the individuals that they sent these letters to that they don't represent and could not represent, and admitted later that they did not represent. There's no reason, and the courts talk about good faith. You can't just say whatever you want to say, like I said earlier, even under the First Amendment. You can't just throw out stuff about a guy's ethics as if the bar condoned.
Well, okay, again, I want to take it in steps if we could.
Sure.
Okay, so the litigation privilege can apply pre-filing.
Under limited circumstances.
Okay, and what is and you say good faith, and that's what the cases talk about.
And a substantial nexus or relationship to the actual need to do it.
Okay, do you believe, what's your best case that says that?
Green Acres. All you got to do is read Green Acres.
All right, so that's the case you want to focus on.
Yeah,
Let me ask you this. Good faith, is it the reasonable belief of the lawyer or the person or the lawyer who is filing the letter? Is that the good faith that we're looking at, their reasonable belief?
Yes, and in part, and that is a factual determination as I read Green Acres. It's a matter of law for the court as to whether a privilege attaches, but it's a matter of fact as to whether it's exercised in, if you will, good faith.
Well, if it's a matter of law for the court to determine, then the court would look to see whether there was a reasonable belief for the lawyer to act in good faith to send out whatever would be a pre-litigation letter, correspondence, or whatever you may want to call it, right?
In part, yes.
That's kind of the test?
In part.
Okay.
I mean, it's more than that. There has to be some reason, again, on the recipient side, as the court discussed with respect to the reporter.
If that's the test, and we're looking at, and it's discretionary with the trial court, whether or not this...
Well, it's a de novo review.
Well, admittedly so, but you're right. It's de novo review. If we're looking at this, we're talking about all of those letters that went back and forth between the two counsels, aren't we?
No, we're not. We're talking specifically about one thing and one thing only. On January 27th, for no reason that I can divine, or they have even come up with, in my opinion, that passes muster, on January 27th, they included a January 6th letter that we contend, and it's not really issued today, was completely defamatory, okay? In various respects, which I won't take the time to go through. that January 6th letter was attached to the January 27th letter they sent out to every homeowner in Mr. Goldman's community that he lives in and that he works in, including his own clients. And that defamatory January 6th letter is what is at issue here. And there is no good reason for that to have been sent in relation to the law that Green Acres establishes. If you just read it, I can go through it with you, but if we want to take the time, there's some great quotes in there that the court completely left out that say what I'm saying. And that is, you can't just send out anything and justify it saying it's ancillary to some litigation I'm contemplating, okay? It's not enough. The court, specifically the Supreme Court, made that clear. You have to have some reason, some reasonable basis to do so and articulate what that is. They have never done that. There was no moratorium that they could have even been involved in as lawyers. So there's no reason, as the court says, no necessity for them to have sent a letter basically besmirching my client's reputation in their community that had nothing to do with any proposed litigation.
Based on what you said, there was no moratorium. I thought the resort had already issued a moratorium by the time the letter
That's
was
correct.
sent.
And they weren't filing any lawsuit over it, and they weren't doing anything over it because the individuals in the association were the ones who had that standing, not their client. And so that's why I'm saying sending it out to individuals they don't represent and had no interest in representing and couldn't represent is absolutely not only defamatory, but cannot possibly be privileged under the Green Acres case.
Is that the only basis upon which there could have, or a lawyer acting reasonably and in good faith would have, I mean, looking at all of those letters that went back and forth?
I'm not sure how all those letters give them
Well,
any justification to send out the issue in this case, which is a defamatory letter, to third-party owners. Now, if they want to send out letters to Mr. Goldman, we haven't sued over those. We haven't sued over those because those would fall probably under the penumbra of exceptions that the court in Green Acres talks about that may be privileged. That's not what we're talking about, Your Honor. We're talking about them sending to third parties unrelated to any such litigation statements that have no bearing on that even possible litigation that those people might choose to file without them involved. And so they had no involvement, as you read the Green Acres case, in any of that. And so they, for no good reason, sent this letter out besmirching my client and defaming him. Now, how is that not actionable? It's the anti-abrogation clause, we've argued. You know, this is a cause of action that existed. The abuse of process claim, turning to that, you know, Rule 48L.
And counsel, let me, as we transition to
Yeah,
count 10.
I did that, and I apologize.
No, that's fine. I just want to make sure I understand
Yeah.
your argument. That's where the anti-abrogation argument that you're asserting
Correct.
clicks in, correct?
That's
It's
right.
count 10 alone.
Yeah, well, you know, I mean, honestly, yes.
Okay.
Under the state of affairs that we're dealing with here today, yes.
And let me ask you, because I want to hear from you
Yeah.
on that. I want to hear from everyone
Yeah,
on
yeah.
that. But has there ever been a time when that constitutional provision has been applied to strike a court rule?
I don't know that it has over in my reading.
And I haven't found one either. So,
Yeah.
I mean,
Yeah, no, I understand.
that doesn't mean it couldn't.
Well, and that's why I'm saying there is some language that I'm trying to remember exactly that talks about various other types of proceedings. But I don't know on the other side whether there's anything talking about whether the rule, but I don't know why it wouldn't apply.
Well, but let me ask you,
Yeah.
it wouldn't bind a Supreme Court's decision in defining the nature of a common law claim, for example. That's not a violation of the anti-abrogation provision. Fair?
I'm not sure what you're saying there, with all due respect.
Sure. A common law negligence claim, say,
Right.
if a statute were to bar such a
Yeah.
claim, that would be right in the jaws of the anti-abrogation provision.
Well,
Would
as
you
I said,
agree?
I don't draw the distinction you are with a rule versus a statute, but yes, the
Bear
answer
with
is
me.
yes.
Okay. But if the court, in construing, on the other extreme, from my point of view, construing what elements, for example, were required for a negligence cause of action, in a case decision, I don't think that would be subject to anti-abrogation. Do you read it the same way, or do you read that differently, that it binds how the court would have to decide a specific case construing the common law?
I'm not sure how to answer that in all candor. I think it's pretty clear that based on the anti-abrogation provision, that that in a particular case, hope I'm answering you, in a particular case, that one could argue, as we are, that would prevent that rule from being applied by the lower court.
Well, and I think, to be fair, we're somewhere in the middle of those two extremes, because we're talking about a court rule as opposed to a specific decision construing the common law in a specific case, or a statutory enactment on the other extreme. But I wanted to try to get the outlier points.
Let me just say this. I don't know that you even need to reach the constitutional issue in this case, as we've argued. And the reason I say that is because if you just look at Rule 48L on its face and strictly construe it, which I think you should, it merely talks essentially about communications to the bar and to certain limited personnel of the bar. Under expressio unis, doctrine, it doesn't say anything to anybody third party can be published and it's okay. It's specifically.
Hold on, stick to abuse of process though, because it does say any civil claim. So if the rule is to prohibit any civil claim, why wouldn't that apply to an abuse of process?
Because I think with all due respect, you're misunderstanding what I'm trying to say, and I don't mean to be disrespectful.
That's why I asked the question.
What I'm saying is, it does bar any civil claim relating to communications made, i.e. content to the bar. That's what it protects. It's mainly to protect the bar, to be candid. But really, it's that simple. It protects communications made to the bar. It doesn't protect in any way, shape, or form communications that are defamatory made to outside third parties that are not in the context of that bar proceeding, which is a private proceeding, by the way, not a public proceeding. It doesn't protect you from going out and just blasting some lawyer.
But your abuse of process is not about, that's why I'm missing the point, is your abuse of process claim isn't about communications they made to a third party.
It is.
Your abuse of process claim, the way I read your complaint.
Oh, I see your point. I'm sorry.
Is made as what they charge they file to the state bar.
It's using, no, it's not what they charge. That's where sorry if I interrupted you. It's the use of a process. The process has nothing to do with what they charge. And that's why there'd be no protection, basically, to put it simply, for vexatious filing of bar complaints by people, particularly if the people aren't lawyers. There'd be no remedy here, and that's why I brought up the anti-abrogation provision only. There'd be no remedy available for anybody who is defamed in the course of the wrongful filing and institution of a case. And it's no different than a litigation. You have abuse of process claims in litigation, which is a judicial process. Why not for a bar proceeding, which I believe to be a judicial process?
Let me ask, and I want to understand your view of what process means for abuse of process. Your argument, as I understand it, is as long as there is a formal process of some type that can be abused, or
No.
is it a court or court-annexed process, or help me understand that.
Sure. I think it has to be, in fairness, a judicial-type process, or quasi-judicial type process, where there's actually hearing, there's a determination made by that bar, in this case, by a tribunal of some kind, which is the case, which is why the bar has conceded that it is a judicial process in nature. So yeah, just to be quick about it, I think it has to be a judicial-type process, not just any old process. I think the bar process is that, as opposed to quickly other kinds of processes that courts have distinguished that may not be subject to being called a judicial process. I believe that, I want to say, for Pani case, for example, court found no process involved in that case, and the reason was it was a complaint to the police or the county attorney, and they didn't find that to be in the case of judicial process, and didn't find the anti-abrogation clause to apply because victims of crimes there are specifically protected under another constitutional provision beyond the anti-abrogation provision, and the two outweighed one another, or the one outweighed the other, and the court felt that therefore it wasn't intended that the anti-abrogation clause apply. That's not our case. This is a judicial process, and the wrongful institution of a proceeding to be vexatious. And of course, as I said, you're right. That isn't. We're not here on the facts of that today. We're just here to determine whether that cause of action can exist and even go forward, as opposed to arguing about whether or not, what was in their mind or whether or not it was vexatious. But clearly the point being made today is that if there is a vexatious claim, and we claim there is, why is that immunized any differently than if you file a case in a court and can be held liable for abuse of process? There's really no distinction with any difference that I can understand, unless the court wants to somehow, as a matter of public policy, which I think would be contrary completely to what Green Acres is talking about, somehow condone vexatious activities by lawyers, which the court expressly did not condone in that case and ruled on, that there's no good faith basis, if you will, for a lawyer to injure his opponent. And it's right in Green Acres, to get back to your point, Judge, that was not held in that case specifically to be a good reason of any kind. And I can't fathom any other reason that was provided to the court as to either what the litigation was they were contemplating, that is the defendant appellees, or counseling anybody on at the time, or having any reason to advise third parties about in terms of Mr. Goldman and his nexus or relationship to any such claim about the moratorium individually. Maybe his client, but he has nothing to do with that. And that's what Green Acres talks about. You can't just argue, well, we have a good reason to do it, which is what they are arguing, because it's always important, that we call out attorney misconduct. They tried that in Green Acres, and the court basically, as my recollection serves me, said no. Because what you're doing by doing that is injuring wrongfully, on the other side of the coin, another attorney, which is unethical and not our public policy. Wow, I didn't realize the time had gone down, and I apologize. I'll reserve what little I have, but sorry.
Very well. Thank you, Counsel.
Yeah.
I look to counsel for appellees, and I don't know who drew the short straw, but.
Good morning, Your Honor. I'm Jim Santos from Jennings, Howden, Cunningham. With me also is Jack Cunningham, and we represent Mark Sahl and the Carpenter Hazelwood Law Firm. Also in the courtroom is Mike Rossi from Elardo, Bragg, Rossi, and Palumbo. He represents Mark and Kayla Sahl individually. Sitting next to me is Jonathan Barnes from Jones, Skelton, and Hockley. He represents the Villas of Copper Wind Associates, the association, if you will, and their management company, Brown Community Management. I'm going to be reserving some time for Mr. Barnes to discuss some issues that are particular to his clients, and I will try to reserve a few moments so I can speak after the Attorney General has a few minutes, because I do disagree on at least some points with what they have said so far. Before I dive into the details of this litigation and the issues that you were just discussing, let me just back up a little bit once and take a look at where we started off with. I know the claim is that the trial judge committed error in this matter, and at least how I normally view civil litigation is that the trial judge is rarely the blame of any error that enters into litigation. Your standard civil lawsuit has 3 lawyers, one hired by a plaintiff, one hired by a defendant, and one appointed by the governor to serve as the judge. All 3 lawyers took the same oath of office. All exist for the primary reason of providing society with a judicial system. And of course, the Arizona Supreme Court controls who gets admitted and who has to be removed from time to time or otherwise sanctioned. We cited Justice Cardozo in the briefs about how he talks about membership of the bar being a privilege, and that as officers of the court, we are basically like the court itself, an instrument or agency to advance the ends of justice. Bottom line is, if error occurred, it's not because anything Judge Kiley did. It's because defendants and their lawyers invited error. We asked for relief that our clients weren't entitled to. I don't believe that happened. In order for me to maybe convince you of that fact, I'd like you to take a look at what we were looking at. 6 months after the complaint was filed, we filed our motions for summary judgment and motions for judgment on the pleading. What target were we aiming at? We were aiming at the target that plaintiff would be unable to satisfy his burden of proof and persuasion on the elements of his claim or overcome any of the defenses being asserted. How do we know what target we're aiming at? We have the allegation of the complaint. We have plaintiff's disclosure statement. Plaintiff's disclosure statement provides us the list of legal issues and factual issues the plaintiff contends are relevant. Plaintiff's witnesses that plaintiff intends to offer at trial, if trial is ever needed. Plaintiff's damages, if you will. And based upon what we saw in their disclosure statement, we made the decision to file our motions. The disclosure statement is part of the record, Record 48, Exhibit D. And I believe if you look at that, you would make the same reach the same conclusion we did. We have a case where none of the witnesses listed by plaintiff, even if they testified as plaintiff listed, would support plaintiff's claims. No damages, no experts. Plaintiff himself chose not to list himself as a witness for good reason. I mean, I'm sure anything he might say would violate the attorney-client privilege, and there may be other reasons as well for him deciding not to open up himself to being deposed, not to offer any of his firm financial records to show that he suffered any damages. Lots of good reasons for someone not wanting to do that. So based upon that, we filed our motions. And then later on, we filed replies. And the reason we filed our replies was because the responses filed by plaintiff still did not satisfy plaintiff's burden of proof and persuasion on the issues that were presented to the court. Plaintiff didn't discuss.
Your time is clicking down,
Yes.
and I'd really like to ask you some questions.
All right.
I was waiting. I thought you were going to get to it, but
I'll-
let me hurry you along a little bit. Let's talk about litigation privilege.
Yes.
The way I understand litigation privilege to work is that pre-filing of a case in court, communications can be subject to litigation privilege. And I'm assuming you agree with me on that statement.
Yes.
Do you have a case that has ever held litigation privilege exists if there wasn't actually a case or settlement to the potential litigation involved? Do you need me to rephrase that?
No.
Okay.
I believe every case we cited talks about the privilege attaching in the event of prospective litigation believed to
Yeah,
exist
but didn't in
good
every one
cause.
of those cases there actually become, that's my question.
Yes, yes, you're right.
In
our
every
case,
one of
though-
those cases, there was actually a case that was filed or settlement that was entered between the parties.
I believe so.
Okay.
But
So you
also-
don't have a case where you're talking about litigation privilege and it exists, that it exists if nothing is filed? Because I think that's their argument.
Their argument is that litigation must be filed, and not one of the authorities discussing the privilege says that. Now, is it as a matter of coincidence that litigation is filed? Yes. Is a lawyer under the burden, or the duty, if you will, to persuade clients not to pursue litigation when they believe litigation would not be fruitful or perhaps not result in affirmative collection? Yes, and we have plenty of those cases as well, that a lawyer's job is to avoid litigation when possible. So when someone is threatened with litigation, as we saw here, threatened with legal action, according to plaintiff, each of the homeowners in the community were worried about skyrocketing attorney fees that would incur if the association and the resort engaged in this litigation that they saw was coming. Shouldn't a lawyer meet with the association, and the association being the agent of the owners themselves, to discuss those facts first? What if that lawyer can avoid taking the bait and avoid pursuing the litigation that perhaps they're trying to be drawn into, and convince their clients that in this case, in this particular set of facts that we have presented in this matter, that litigation would not have been profitable? Because really, that's all we always look at. It doesn't matter whether we're right or wrong in civil litigation. It matters whether it would turn into a collection of money or other benefits.
Okay, and I'm going to assume that there was a reason, some reason based on the letters that had exchanged for some type of communication with the individuals that you mentioned. But why was it necessary to include the potential bar complaint, or or I'll refer to as the bar complaint letter that was attached to that end of January letter to all of the Villa members?
Well, first of all, Mr. Sahl provided his letter to his client, the association. I don't think that anyone is complaining about that.
And when
Who
you say
else
the
could he
association, you're talking about the board or
The board members
board members?
are the people. The
But didn't he
association is the client,
Okay,
and the association serves as the agent of the owners, is appointed under the CC&Rs to act as their agent for these types of purposes. So, no, I don't think anybody's complaining that you can't provide your client with a copy of correspondence exchange between counsel, even if that contains accusations back and forth with regard to that. I mean, if that were the case, it's not the case, and nobody has cited any authority that says you can't tell your own client what was said or done in between. But first of all, to answer your question directly, in Mr. Goldman's letters when he was representing the resort, as opposed to Ms. Nolan, he was saying that there was continued antagonistic conduct on behalf of the board that was causing them to retaliate against each homeowner and remove their privilege to become members of this resort and to drive for the purpose of driving down the value of their homeowners' property values, including Ms. Nolan's property values, just because the resort was mad that people had spoken up at a town council meeting. They had the right to do that. They don't have to do business with anybody they want to. But the threat was that the conduct of Mr. Sahl and communicating with Mr. Goldman was evidence of antagonistic conduct. So, wouldn't your clients want to know? The ones who have to pay your attorney fees, the homeowners, which is why the Club Valencia and the Seahouse case cited in the materials say that the privilege protects an association's lawyer communications with the homeowners, and there's no authority that has ever said otherwise. Wouldn't it be beneficial to explain to the homeowners where this antagonistic conduct may have come from? Maybe it was his fault. Maybe he was antagonistic by saying those words to Mr. Goldman. I don't believe so. I mean, I think everything he did was 100% correct. I don't think there's any defamation. I think the bar complaint that he filed by filling out the online form was entirely appropriate. But even if it weren't, why wouldn't you have to come clean to your client and say, you know what, I said a few words that perhaps is adding fuel to the fire on behalf of Mr. Goldman or one or more of his clients that he represents? Well, that's what I would do. The other reason why is I have a candid discussion with my clients every time about the opposing counsel. Not every lawyer is the same in Arizona. There are some that are bad. I would discuss those who are, I believe, bad with my client and say, here's why I think they're bad. They take unnecessary positions, they churn files, they maybe retaliate at every chance and opportunity rather than to focus on the narrow issues. So you have to be able to have those candid discussions with your client. And, in this case, the homeowners who actually are the ones paying for all the attorney fees that the association incurs. The ones, as Mr. Goldman said, deserved complete candor and transparency of what happened between the resort and the association. And that would include, if there were any, some name calling or other type of communications, just so there's complete candor and transparency. If I could jump to the process part two, I believe the Attorney General will talk a little bit about this issue as well, but every authority we cited, either in the answering brief or in the response to the amicus brief, that discusses whether or not submitting an online form to the State Bar of Arizona or similar organizations constitutes the use of process for an abuse of process claim, all have said no, it is not. I would respond to those authorities that say yes, it is, but there are none. There were none in the opening brief. There were none in the reply brief. Clearly, filling out online forms is much more the reporting to a police officer scenario that we have, or just plain flat out not an abusive process under the court cases that we did cite, discussing submitting bar complaints are not the use of process and therefore cannot be the abusive process. And it's also not, of course, a process used in an incorrect manner. There's only one way you can report suspected attorney misconduct, especially if you think you have the obligation to under ER 8.3, and that's to fill out the online form. There is no other way to report that type of conduct to the State Bar.
But wouldn't that argument imply, you're talking solely about the process, right?
Process.
I mean, if somebody just made things up and communicated into the State Bar, your argument would be the same.
You're right. Have that happen to me. State Bar gives you a call and says, hey, somebody called and had some sort of weird claim. We handled it.
And so there would be no, from your perspective, there's no remedy cognizable in civil courts in that context.
No, especially here, under these set of facts where there's been no damages.
And I understand that the hypothetical
Yeah.
that I'm talking about is just that. But
Yeah, no, nobody's using process there, or in that matter, abusing a process. It just doesn't happen. There's no use of process at all.
So
Process,
if the state bar in what you said happened to you had actually filed a bar complaint, and you'd had to generate fees to have somebody represent you, and then ultimately the bar said, "Yep, you were right. There's nothing to see here." Wouldn't you have a remedy of going after the person who made stuff up against you?
Your Honor, when I took my oath, I took the same oath that everyone did, and I'm going to follow the rules that are announced by the Supreme Court of Arizona, including the current version of Rule 48L, but it's appeared in different rules. I think 54 beforehand. I think it might have been even Rule 80 at some point in time. And I have agreed not to, for the benefit of protecting society's interest in having a judicial system they can count on, I've agreed not to pursue claims against those who
Well,
report my misconduct.
let's say you wanted to.
or let's say it's a non-lawyer who does that, not bound by that oath.
I'm bound by the oath.
I understand.
I took the oath that I won't pursue anybody who reports
I think we're just trying to get a
suspected
more direct
misconduct
answer to the
against me.
question. Is there a civil claim available?
There is not,
Why?
because I've agreed not to.
Well, that's not an answer. Do you have because that's a personal answer. I'm
Well-
saying, can legally,
Yes.
someone who wants to, can they file an abusive process?
No,
And why not?
multiple reasons. One, it's not the use of process. It's not neither criminal nor civil, and I can't find any cases that say bar proceedings are a third version of the type of process that can be abused. Second, our Arizona Supreme Court, under the Constitution, has the duty of protecting the judicial branch of the government in our state. Every court has looked at this, say this is something that the Supreme Court holds dearly. It has to be self-governing. In order to maintain self-governing, it has to have the right to admit or punish or dispose of lawyers
Those are
who admit to the
administrative.
bar.
That's an administrative function.
Oh, not at the end. At the end, the last final word we're going to hear is from the Supreme Court. When the Supreme Court says that someone has been disbarred, it comes out of their mouth, not
Okay,
from the
but they
administrator.
still have administrative rules, right? They have administrative rules. They've promulgated rules just like any other administrative agency would do that would regulate a particular profession, whether it be the medical board or whether it be the lawyers in the state bar.
Yes, except for the Supreme Court's rules are in protection of its constitutional duty to maintain integrity in the judicial system.
And that trumps the anti-abrogation clause.
It never existed beforehand. You will not find any case in Arizona where they've adopted a common law remedy of a person who's been reported to the bar, or back in the old days, directly to a judge for attorney misconduct. It never has happened in Arizona, and we know why, because their privilege protects that, and the privilege is needed in order to maintain.
The
Not
privilege
for
they
me.
adopted in the 60s once they had rulemaking authority?
No, the privilege goes back to the 1500s, 1300s. I mean, the privilege goes way back to those who are reporting attorney misconduct to a judge. Supreme Court cases we cited in our case, I believe we're the only ones who cited the pre-1912 authorities discussing how long this privilege has existed to protect those involved in attorney misconduct proceedings. It's been there forever, and it's there because we need to have it in order to protect the integrity of the judicial system, and our society needs a judicial system. So it's there for constitutional grounds as well as for procedural grounds as well. And our Supreme Court has refused to accept review of Drummond, of Sahl, Sobel rather, and all the other cases where this issue has already been decided at the Court of Appeals level. You cannot find in favor of plaintiff unless you reverse current existing law that has stood the test of time and has never been reviewed by the Arizona Supreme Court. Rule 48L is perfectly clear. It's not unconstitutional, nor was the constitutional challenge correctly presented to our trial judge. They didn't meet their burden of proof and persuasion in convincing the trial judge that their constitutional challenge was worthy. They have a strong burden of proof in proving something is unconstitutional. They didn't come close to that. Your Honor, I'm going to reserve some time, for the,
Very well.
thank you. Mr. Barnes?
Mr. Barnes, you may proceed. You have about 2 minutes.
Good morning. My name is John Barnes. I'm here for the association, Brown Community Management, and the Flynn's. There's just one point that I wanted to emphasize from the briefing regarding the abuse of process claim, and that is this. The record lacks evidence that the association defendants knew about, participated in, or controlled the bar charge filed by Mr. Sahl. And that presents an independent reason to affirm summary judgment for my clients. And unless there are questions for me on that point, I'll reserve the remainder of the time. Thank you.
This time we'll now hear from Mr. Crandall on behalf of the Amicus Arizona Attorney General's Office.
May it please the court. I am Rusty Crandall here on behalf of the Arizona Attorney General, Mark Brnovich. Thank you for giving the Attorney General the opportunity to participate in this case. This case is tricky, but it becomes easier when we focus on first principles. With the limited time that I have, I want to discuss 3 basic concepts that make this case a little bit easier. First, a judicial proceeding is not the same thing as a judicial process. Whether a statement is made preliminary to or as part of a judicial proceeding is relevant to whether the judicial statement privilege applies. In contrast to this, whether a judicial process is involved concerns an element of the abuse of process claim. A judicial process generally requires a specific act that is done under the authority of the court. Thus, a judicial process is narrower than the concept of a judicial proceeding. The second concept I'd like to mention, it's common to refer to someone as having filed a bar complaint, but filing a bar complaint is not the same thing as making a bar charge. Anyone can make a bar charge, but only bar counsel can file a bar complaint. Thus, a bar complaint can be done under the authority of the court. A bar charge, however, does not need to be done with court authority. As such, simply accusing an attorney of misconduct cannot give rise to an abuse of process claim. The third concept is this. A claim for abuse of process is not the same thing as a claim for malicious prosecution. To prevail on a malicious prosecution claim, a plaintiff must show, among other things, that an action was terminated in favor of the plaintiff and that the action lacked probable cause. An abuse of process claim does not require either of these elements. It requires different elements. In his briefing, defendant mistakenly cites the elements of a malicious prosecution claim as the elements of an abuse of process claim. But this case is about abuse of process, not malicious prosecution. And just because an abuse of process claim might fail, that does not mean that a malicious prosecution claim might not succeed. A malicious prosecution claim is all about whether the action itself was properly initiated. I would refer the court to the Connecticut Supreme Court's decision in Rue v. Berry, 927 A. 2nd, 304, and the dissenting opinions in the Kentucky Supreme Court's decision, Morgan and Potter, 348 Southwest 3rd, 599. These cases concern why it's important to make recourse available for malicious prosecution. But again, this case is not about malicious prosecution. As such, the court should clarify in its decision that it is not addressing whether a malicious prosecution claim might be permitted when a bar charge is maliciously made. Unless the court has any questions, I'll sit down.
Thank you, counsel. We appreciate that. Mr. Santos, you have about 90 seconds left.
Thank you, Your Honor. And as to that part of the AG's brief, I do agree. And I can even supplement what he was saying is based upon some of the things we already put in our briefs, that a party filing a bar charge is not a party to any proceeding, cannot have process issued in the forms of subpoenas, summons, depositions, you name it, all the things that we normally see in an abuse of process claim. In fact, has no control whatsoever over the issues at all. Instead, bar counsel at the state bar is the one and only person who can initiate a complaint. And we know from Lukowitz and some of the other decisions, due process rights to those who are accused attach upon the filing of the complaint, the right to a hearing, the right to cross-examine witnesses. That's what we consider process. It does not occur in the initial online form that the state bar offers or encourages people to fill out. Thank you.
Thank you. Mr. Wilenchek, you will get the last word. We'll give you 90 seconds to approximate what we just heard.
Thanks. I'll move through this as quickly as I can. First of all, and I hope I don't go too quickly, if the bar process is not a process, then I'm curious, don't have the time to go into it further, how there could be a pre-litigation privilege attaching to that process. Secondly, we dispute clearly some statements made by counsel. The cases that he cited, Drummond versus Stahl, et cetera, those are defamation cases, not abuse of process cases. As to the HOA, we're told by Sahl's counsel here in court that the HOA sent the letter, so there's some dispute on that. And the bar charge does initiate a process, as the bar itself stated in its briefing. That process and procedure starts as of the filing of the bar charge. And to clarify, abuse of process deals with improper filing for improper purposes as much as a malicious prosecution claim, and frankly, more so. So Rule 48 is clear as far as I'm concerned, and it does protect the content of any claims made in the bar proceeding, similar to a litigation proceeding. It does not protect, however, a vexatious, malicious, or repetitive filing against an attorney who has rights to stop that. And what they're telling us today, to come back to something you asked, Judge Thumma, is there's no recourse at all if somebody vexatiously continues to do that to a lawyer. Lawyers don't have rights to bring a claim saying, no, it's defamatory or an abuse of the process to vexatiously do that. And that's just silly to me. But my time's up. Thank you very much.
Thank you. Counsel, we appreciate your presentation today. We appreciate your briefing. We also appreciate the briefing of the several amici who helped us out as well in response to the order that the court issued. You've given us much to think about. We will take the matter under advisement. We'll issue a written decision in due course, and the court stands adjourned. Thank you.
Take care.